Madam Chief Justice, and may it please the Court. My name is Monica Haddad, and I, along with my co-counsel, Alex Landvath, represent the petitioner, Mr. Samuel Millstone, in the appeal before this Court. I would like to reserve 2 minutes of my time for rebuttal. The term negligently in Section 1319 C1A of the Clean Water Act does not mean a civil standard of negligence, and notifying a potential witness of his constitutional right to invoke the Fifth Amendment does not rise to the level of corruptly persuades. Therefore, this Court, on de novo review, should reverse the judgment of the 14th Circuit and hold that petitioner's due process rights were violated. I will be addressing the Clean Water Act, and my co-counsel will be addressing witness tampering. The holding of the 14th Circuit as to the Clean Water Act was incorrect for 2 main reasons. First, a civil negligence standard in the context of a criminal statute is not the correct standard of negligence. And second, since the Clean Water Act is not a public welfare statute, a higher mens rea is required to convict. Section 1319 C1A of the Clean Water Act states that any person who negligently violates Section 1311 of the Clean Water Act shall be punished by a fine of not less than $2,500, nor more than $25,000 per day of violation, or by imprisonment for more than 1 year, or both. Section 1311 states that the discharge of any pollutant by any person shall be unlawful. This is a very broad statute in this case. And moving to the first point, the ordinary negligence in the context of a criminal statute is not appropriate based on this Court's well-established framework that whenever there is a mixed statute, the Court should look to distinct definitions and not use the civil standard to interpret a criminal statute. In this case, additionally, we have, this Court has stated in United States versus United States Gypsum Company that when Congress does not provide the definition of the term that it uses in a statute as to mens rea, it has looked to the model penal code, which in this case would suggest a higher standard of care, a standard of gross negligence. Therefore, since this is a criminal statute, the absence of the definition of negligently within the Clean Water Act, this Court should move to interpret the statute as the gross negligence standard.
Why can't we just look to the ordinary meaning of the statute? It
Your
doesn't say gross negligence, it says negligence.
Yes, Your Honor. However, that goes to this Court's duty to possibly look to the broader context of the statute as a whole. It is a criminal penalty. It has that heading within the statute. There is a different mens rea throughout the statute. However, it would just lead to an absurd result in this case if we are only relying on prosecutorial discretion to determine which charges to press in each case. And additionally, in some instances throughout the Clean Water Act, specifically 1321 B7D, it's actually harder to impose civil fines than imprison someone under C1A in this case. So therefore, this Court should take a more holistic approach in interpreting the statute to find that a higher standard of care was necessary. Additionally, the 14th Circuit's reliance on United States versus Haddad was misplaced, since in that case it relied on United States versus Weizenhoff, an earlier case which interpreted C2 of Section 1319, which uses a knowingly mens rea, and stated that it was a public welfare statute. In that case, it was only looking to whether a statute protects the public. That means it's public welfare. But after that case, we have Staples versus United States, which has indicated that this Court is reluctant to expand the scope of the public welfare offense doctrine and maintain it as a narrow category, since the Court is reluctant to criminally convict those who do not indicate any level of culpability or knowledge of their acts. Turning to the public welfare statute, this is not a public welfare statute based on the broad nature of possible activities that would fall under its category. Looking back to Section 1311, we have the discharge of any pollutant by any person shall be unlawful. That does not put a reasonable person on notice, and also the severe penalty of possibly 1 year of imprisonment does not lend itself to being a light penalty with no harm to reputation, as this Court, throughout its evolution of the case law of public welfare offenses, has stated that that is one of the key factors.
Give us an example of a public welfare statute and why it's different from the Clean Water Act.
Your Honor, in United States versus Freed, this Court looked to the National Firearms Act and interpreted a specific provision which dealt with the possession of hand grenades as being a strict liability offense, and someone could be convicted without knowledge that they needed to register a hand grenade. That would be an example. One stands has a dangerous or deleterious item that they know is likely to be subject to regulation, and the penalties would be light in that case. Additionally, in Staples, this court took a step back from dangerousness as being the only factor as to whether it's a public welfare statute. Therefore, in this case, whether or not the chemicals would necessarily automatically lend it to be a public welfare statute is not indicative. Instead, this court should go through the entire analysis and review whether a reasonable person would be on notice. In this case, Petitioner was an independent contractor who merely took on a new project within an attempt to grow his business, and the fact that he can be held criminally liable when he had absolutely no involvement in the chemicals themselves or their production or storage would seem to be extreme in this case, and therefore it would not be a public welfare in that aspect. Additionally, since the dangerousness is not dispositive and a one-year penalty is severe, that again goes against it being a public welfare statute.
Well, the court in Staples was also concerned about calling a statute that can impose a 10-year prison term a public welfare statute. Here we're only dealing with 1 year.
Yes, Your Honor, that's correct. However, it was up to 10 years. In this case, what we have...
And here it's up to 1 year, right?
Yes.
Okay, and why is up to 1 year too much, too serious to call this a public welfare statute?
Based on this court's reluctance to send people to prison, especially if it's just going to be a negligence standard, it would be too much of a penalty in this case to have to send someone for 1 year who had absolutely no reasonable expectation that they would be subject to this regulation, since the discharge of any pollutant into the waterways could be subject to imprisonment.
Well, you're not arguing that no statute can be a public welfare statute if it imposes any prison term, are you?
No, Your Honor. It's just in this case, 1 year penalty for Mr. Millstone would be severe, since he didn't have any expectation that he would fall under the statute in this case. Additionally, United States versus Haddad and United States versus Ortiz are the only courts that have stated that a statute, the Clean Water Act, Section C1A, does fall under the public welfare offense doctrine. Instead, this court should look to United States versus Ahmad, which stated that after Staples, that it recognized that this court is reluctant to expand the scope of the public welfare offense doctrine, and stated that the Clean Water Act is not public welfare statute. So this court should look to the opinion in United States versus Ahmad, which the court there was concerned that criminalizing otherwise lawful conduct, if one doesn't know the regulation that is at stake in this case, would lead to it not being reasonable to convict that person.
Are there any other instances where a statute or a court has held that a statute can criminalize ordinary negligence?
Your Honor, the only case that comes to mind at this point from this court is United States versus Ballant, where the distribution of drugs was held that it was just an ordinary negligence standard. Someone could be convicted if their drugs were mislabeled or misbranded in that case because of the public danger. However, in 1952 in Morissette versus United States, this court stated that Ballant has been taken too far. Again, in Morissette, retreating from imposing a no mens rea standard in a case of a common law crime of conversion or stealing. So, again, Ballant is used by the government to always bolster its argument that negligence is enough. However, this court already stated 30 years after that decision came out in 1922 that has been taken too far. So this court, again, should look to its own opinions to see that this should be a restricted category reserved for only specific instances. Also persuasive is the dissent from the denial of certiorari in the United States versus Haddad, which came up to this court, and Justice Thomas, the same justice who wrote the opinion for Staples, stated that Section 1319 C1A is not a public welfare statute because it would criminalize ordinary industrial and commercial activities. That is exactly what we have here when we have Mr. Millstone, who's being sent to prison for engaging in a business, providing a security service to a company, and then being sent to prison for it. Again, someone's lack of knowledge in that case would not be reasonable to send them to prison. Additionally, since the statute can be subject to different meanings, different interpretations as to the negligence, this court should use the rule of lenity to interpret this ambiguity in favor of protecting Mr. Millstone's due process rights and reverse the decision of the Fourth Circuit.
Can you explain me, let's go back to Haddad for a moment. You just discussed the dissent, the denial of cert. Let's set that aside for a minute. How is this case dissimilar from Haddad in your view?
Your Honor, in that case, the defendant, Haddad, was actually negligent for a period of time. In the government's brief to the Ninth Circuit in support of their appeal, they stated that defendant Haddad was specifically hired to supervise all his employees to be on the site where this railroad track project was being, there was rocks being removed from a railroad track area. And there was a lot of evidence indicating that the main practice was to put some kind of indication on an oil pipeline that to prevent someone from causing rupture in the pipe. In this case, we have Mr. Millstone, who, according to page 7 of the record, would check in on his project periodically. He would make sure that his clients were happy with the project, whereas in Haddad, he knew for months leading up to the accident that safety procedures weren't being followed at the track where there was a rock quarrying project going on.
So you can get out of potential criminal liability by being, for lack of a better term, an absentee landlord?
No, Your Honor, Millstone was actually, Haddad was sentenced to 6 months of imprisonment, 6 months in a halfway house and 6 months of probation and a $5,000 fine. Here we have Mr. Millstone who's being sent to prison for a year, and he has potentially a $75,000 fine. There is actually a more severe penalty on Mr. Millstone than on defendant Haddad. I'm not sure if that answers your question.
Well, what I was getting at is if I understood you correctly, you were saying in Haddad, his problem was he was boots on the ground and he knew what was going on and should have known better, whereas your client was not boots on the ground as often and thus had no notice of what's going on. Is that a fair articulation of your position?
I actually misstated. What I meant was that defendant Haddad had many opportunities to correct his prior failure, a gross deviation from the standard of care when considering removing rocks from a dangerous area in Alaska next to an oil pipeline. Instead, Mr. Millstone here was the opposite. He was checking periodically on the site. He was in charge of training his employees, and he took a more proactive approach than defendant Haddad in that case.
I maybe headed backwards then.
I'm sorry. In conclusion, this court should interpret negligently in Section 1319C1A to be higher than an ordinary standard of negligence. And this court should also avoid expanding the public welfare offense doctrine to include Section 1319C1A and the Clean Water Act, since it is inconsistent with this court's reluctance to keep the category of the public welfare offense doctrine narrow. For all these reasons, this court should reverse.